Good day, everyone. I am Jody Marian Tibo, and I will be the next reporter. Investor in tourist-related project or tourist establishment under Executive Order Number 63. The investor, his wife, and unmarried minor children shall be permitted to enter and reside in the Philippines as special investor residents for as long as the investment of $50,000 subsists, provided that 1. They have not been convicted of a crime involving moral turpitude, 2. They are not afflicted with any loathsome, contagious, or dangerous disease, and 3. They have not been institutionalized for any mental disorder or disability, and provided further that said investor visits the country at least twice a year and stays in the country at least 7 days for each visit. The said investor, his possessed and unmarried children shall be issued a multiple entry special investor resident visa to enter and leave the Philippines without further documentary requirements other than valid passports or other travel documents in the nature of passports. They shall be exempted from payment of alien immigration and registration fees and from securing alien certificates of registration. Should the investor withdraw his investment from the Philippines or transfer his investment to any other area without the prior approval of the committee created therein, the special investor's residence visas issued to him, his wife and unmarried minor children may be revoked by the Philippine government. For this purpose, he shall submit an annual report for the purpose of proving that he has maintained his investment in the country. Application of the law. Case. On May 7, 1999 at about 11 p.m., the National Bureau of Investigation or NBI, in coordination with the Department of Labor and Employment or DOLE and the Bureau of Immigration or BI, conducted simultaneous raids at the Royal Flame Club, Space World and Narcissus Club, which are all located in Ermita, Manila, as a result of which 20 female Chinese nationals were caught in the act of entering customers and guests. A charge sheet was filed on May 14, 1999 against these 20 female Chinese for violation of Section 37A.7 of the Philippine Immigration Act of 1940. Violation of any limitations under which they were admitted as non-immigrants. Chinese national Ma Jing was one of the 20 apprehended Chinese. It appears that she is not really an undocumented alien, as she has a valid PROC passport number 143777 and visa been duly extended up to June 30, 1999 under OR number M7922945. She was not notified of the Commissioner of Immigration or any competent authority to justify her continued detention. Discuss the validity of the arrest and detention of Ma Jing. So, the detention and arrest of Ma Jing is illegal. Accusation is not synonymous with guilt. The strongest suspicion must not be permitted to sway judgment. The illegal arrest of Ma Jing without warrant of arrest or seizure on May 7, 1999, and her arbitrary detention is not remedied with a supposed filling in a charge sheet which was filed on May 14, 1999. Ma Jing had been detained without any valid charge from May 7, 1999 to May 14, 1999. The filling of the charge sheet did not cure the illegal detention of Ma Jing. Additional requirements prior to entry. For non-immigrants, A valid ticket for a return journey to the country of origin or to the next country of destination is required for presentation. Certificates of residence must be secured by the following categories of non-immigrants from the Bureau of Immigration. A. Temporary visitors, B. Students, and C. Pre-arranged employment. Foreigners entering as non-immigrants may also be required to register in accordance with the provisions of the Alien Registration Act as follows. A. Any alien who is in the Philippines at the time of the approval of the Alien Registration Act and who is 14 years old of age or more and will remain in the Philippines for 30 days or longer. B. Any alien who enters the Philippines after approval of the Alien Registration Act of 1950 and who is 14 years of age or more and who will remain in the Philippines for 30 days or longer. C. Every parent or legal guardian of any alien child who is in the Philippines at the time of the approval of the Alien Registration Act of 1950 and who is below 14 years of age and will remain in the Philippines for 30 days or longer. D. Every parent or legal guardian of any alien child who enters the Philippines after the approval of said act and who is below 14 years of age and who will remain in the Philippines for 30 days or longer, provided, however, that this provision shall not apply to an alien child admitted into the Philippines as a temporary visitor or transient, unless said child will remain in the Philippines for 60 days or more. E. Every parent or legal guardian of any alien child born in the Philippines. F. Wherever an alien attains his 14th birthday in the Philippines. Lastly, it is imperative for government medical offers, immigration officers, and the Board of Special Inquiry to conduct a sufficient medical examination of all aliens arriving in the Philippines. Such examination is focused on physical and mental health, or may extend on the inquiry of the character of arriving alien. Any alien who fails to meet the health and character standards established by immigration laws, rules, and regulations for entry and admission shall be excluded under Section 29 of the Immigration Law. Extension of stay. In the case of non-immigrants, visa holders whose stay in the Philippines will exceed 59 days, the consular officer shall advise them that they should secure extensions of stay and register with the Bureau of Immigration and pay the necessary immigration fees. The entry and admission of an alien are matters of privilege, and there is no ministerial duty on the part of the Commissioner of Immigration to extend the stay of a temporary visitor. The power of the Commissioner of Immigration to extend the stay of a temporary visitor is plenary. He is visited with the power and authority to grant such extension. Therefore, the Secretary of Foreign Affairs is not authorized to admit into the Philippines aliens for temporary stay, or to extend the temporary stay of alien visitors in this country, as the law vests such power in the Commissioner of Immigration. Application of the law. Case. Chang Yong-fa was admitted to the Philippines on pre-arranged employment as immigrant under Section 13A of the Philippine Immigration Act of 1940, with the express condition that his stay shall be limited to 2 years and should be failed to comply with said condition after the expiration of that period, he shall be subject to deportation. Chang Yong-fa consented to such condition. In such condition, within the power of the Commissioner of Immigration to impose. So yes, such condition is within the power of the Commissioner of Immigration to impose. The power of the Commissioner of Immigration under Section 20 of the Commonwealth Act Number 613 should include the authority to impose such limitation. For if the Commissioner has the power to deny completely the admission of an alien who seeks to enter this country on a prearranged employment by withholding the issuance of an immigration visa on the ground of public interest, with more reason can he impose a condition which is less onerous, just as limiting the duration of his stay in the country. Having consented to his admission under such condition, Chang Yong-fa cannot now be heard to complain that the Commissioner of the Immigration acted in excess of his power in imposing the limitation. Chang Yong-fa is now under estoppel from disputing such power. Application of the law. Case. Chang Yong-fa was admitted to the Philippines on prearranged employment as immigrant under Section 13A of the Philippine Immigration Act of 1940, with the express condition that his stay shall be limited to 2 years and should be failed to comply with said condition after the expiration of that period, he shall be subject to deportation. Chang Yong-fa consented to such condition. In such condition, within the power of the Commissioner of Immigration to impose. So yes, such condition is within the power of the Commissioner of Immigration to impose. The power of the Commissioner of Immigration under Section 20 of the Commonwealth Act Number 613 should include the authority to impose such limitation. For if the Commissioner has the power to deny completely the admission of an alien who seeks to enter this country on a prearranged employment by withholding the issuance of an immigration visa on the ground of public interest, with more reason can he impose a condition which is less onerous, just as limiting the duration of his stay in the country. Having consented to his admission under such condition, Chang Yong-fa cannot now be heard to complain that the Commissioner of the Immigration acted in excess of his power in imposing the limitation. Chang Yong-fa is now under estoppel from disputing such power. Exclusion of foreigners. The law. Section 29A, the following classes of aliens shall be excluded from entry into the Philippines. 1. Idiots or insane persons and persons who have been insane. 2. Person afflicted with a loathsome or dangerous and contagious disease, as epilepsy. 3. Person who have been convicted of a crime involving moral turpitude. 4. Prostitute or procurers or persons coming for any immoral purpose. 5. Persons likely to become public charge. 6. Paupers, vagrants, and beggars. 7. Person who proctors polygamy or who believe in advocate the practice of polygamy. 8. Person who believe in advocate the overthrow by force and violence of the government of the Philippines, or of constituted law and authority, or who disbelieve in or oppose to organized government, or who advocate the assault or assassination of public officials because of their office, or who advocate or teach principles, theories, or ideas contrary to the Constitution of the Philippines, advocate or teach the unlawful destruction of property, or who are members of or affiliated with any organization entertaining or teaching such doctrines. 9. Person over 15 years of age physically capable of reading who cannot read printed matter in ordinary use in language selected by an alien. 10. Persons who are members of a family accompanying excluded alien, unless in the opinion of the Commissioner of Immigration no hardship would result from their admission. 11. Person accompanying an excluded person who is helpless from mental or physical disability or infancy, with the protection or guardianship of such accompanying person or person is required by the excluded person, as shall be determined by the Commissioner of Immigration if otherwise admissible. 12. Children under 15 years of age accompanied by a parent, except that any such children may be admitted in the direction of the Commissioner of Immigration, if otherwise admissible. 13. Stowaways, except that any stowaway may be admitted in the direction of the Commissioner of Immigration, if otherwise admissible. 14. Person coming to perform unskilled manual labor in pursuance of a promise or offer of employment, express or implied, but this provision shall not apply to persons bearing passports visas authorized by Section 20 of this Act, as amended by Republic Number 503, Section 10. 15. Persons have been excluded or deported from the Philippines, but this provision may be waived in this creation of the Commissioner of Immigration, provided, however, that the Commissioner of Immigration shall not exercise his direction in favor of aliens excluded or deported on the ground of conviction for any crime involving moral turpitude or for any crime penalized under Section 45 and 46 of this Act on the ground having engaged in hoarding, block marketing, or profiteering unless such aliens have previously resided in the Philippines immediately before their exclusion or deportation for a period of 10 years or more, or are married to a native Filipino woman, as amended by Republic Act Number 503, Section 10. 16. Persons have been removed from the Philippines at the expense of the government of the Philippines as indigent aliens under the provisions of Section 43 of this Act and who have not obtained the consent of the Board of Commissioners to apply for readmission. And 17. Person not properly documented for admission as may be required under the provisions of this Act. Of the law. International law affords sovereign states absolute discretion to determine whether or not an alien is disqualified for entry into its territory. As a general rule, an alien's fitness for entry depends on whether he or she possesses a risk to the general welfare. If an alien's entry will threaten national security, public safety, public health, and public morals, and the state can declare such alien as being ineligible for entry. Exclusion is defined as the authority to deny entry to the aliens who are barred by immigration laws, rules, and regulations. The purpose of exclusion is to ensure that aliens who are allowed entry into the Philippines do not pose as threats to any of the three major categories of exclusion grounds, namely public safety, public health, and national security. As a general rule, an order of exclusion of final and executory and bars the alien from entry or admission in the Philippines unless waived by the Commissioner of Immigration under Section 29 of the Philippine Immigration Act of 1940. In all cases, the burden of proof is upon the alien to establish under the oath before the immigration officer and the board or special inquiry that he does not fail in any of the categories or excludable aliens under Section 29. Application of the law. case. The three petitioners, Dolores, Felix, and Manuel, all surnamed Nuria, arrived in Manila from Hong Kong on board Cathay Pacific Airways on July 9, 1961. The matter of the admission of Dolores, Felix, and Manuel Nuria was referred to the Board of Special Inquiry Number 1, which on August 2, 1961, after investigation, found Dolores Nuria to be a Filipino citizen and Felix and Manuel Nuria to be her illegitimate minor children by a Chinese national. Gan Chung Bing and accordingly voted to admit them, pursuant to Section 27B, 1 of the Philippines Immigration Act of 1940. The decision admitting Dolores, Felix, and Manuel Nuria was forwarded for review to the Board of Immigration Commissioners. There was no evidence of any hearing by the Board of Commissioners. However, the identification certificates issued to Dolores, Manuel, and Felix Nuria on September 1, 1961, explicitly and uniformly recite that they had been admitted as citizens of the Philippines as per decision of the Board of Special Inquiry dated August 2, 1961, duly affirmed by the majority members of the Board of Commissioners. On August 8, 1962, or a period of 1 year from the decision of the Board of Commissioners has lapsed, a new Board of Immigration Commissioners reviewed the proceeding of the Board of Special Inquiry with respect to Dolores, Felix, and Manuel Nuria, and finding that they have not satisfactorily established their claim to Philippine citizenship, ordered them excluded as aliens not properly documented for admission pursuant to the provision of Section 29A. 17 of the Philippines Immigration Act of 1940, and return to the port where they came or to the country of which they are nationals. On July 23, 1965, the Commissioner of Immigration issued a warrant of exclusion under Section 27B of the Philippines Immigration Act of 1940 for the apprehension and eventual deportation of the petitioners. Discuss the validity of the issuance of the warrant of exclusion by the Commissioner or Immigration against petitioners Nuria. So such warrant of exclusion is null and void. It has been ruled that that decision of the Boards of Special Inquiry becomes final. It is not appealed to, reviewed, or reversed by the Board of Commissioners within 1 year from its promulgation. Since the Board of Commissioners promulgated a new decision only after a period of 1 year has elapsed, it is but proper to commence deportation proceedings under Section 37 of the Philippines Immigration Act of 1940. Accordingly, no warrant of arrest should be issued by immigration authorities before a final order of deportation is made. For until it is established that an alien lawfully admitted gain entry into the country through illegal means and his expulsion is finally decreed, his arrest cannot be ordered. The issuance of warrants of arrest by the Commissioner of Immigration solely for purpose of investigation and before a final order of deportation is issued conflicts with Article 3 Bill of Rights of our Constitution, providing the rights of people to be secure and their persons against unreasonable searches and seizures. So that's all about my report. Thank you.